Supreme Court just ended gun permits. What this means for every state. A Supreme Court ruling changed gun permits across America, and a lot of people still do not understand what it really did. If you think your state can still make you beg for permission to protect yourself, you need to hear this right now. Quick question before we continue. Are you subscribed? Because what I'm about to explain could keep you from trusting the wrong advice, following the wrong rule, and walking into legal trouble you never saw coming. Hit that subscribe button right now, because gun laws change fast, and the people who wait to learn about them usually learn the hard way. Here's what just happened, and here's why the title sounds bigger than the legal wording. The Supreme Court did not wipe out every gun permit in America. It did something more specific, and in some ways more powerful. It killed the idea that a state can force an ordinary, law-abiding person to prove some special reason before carrying a handgun in public for self-defense. That came from the Bruen decision, the case out of New York that changed the rules for the whole country. Before that case, New York had a system that said, in simple terms, you do not just get a carry permit because you want to defend yourself. You need to show a special need. Not just fear, not just caution, not just the fact that crime exists. You had to prove you were different from everyone else. Think about that for a second. Imagine you live in a rough neighborhood. You get off work late. You have cash on you sometimes. You walk through a dark parking lot. You want a concealed carry permit. Under that kind of rule, the state could still say no because your danger was not special enough. That is the part the Supreme Court blew up. The court said the Second Amendment protects a person's right to carry a handgun in public for self-defense, not just inside the home, not just in theory, in public. And the court said states cannot deny that right just because some official thinks you did not show a good enough reason. That was the earthquake. But here's the crazy part. A lot of people heard that ruling and jumped to the wrong conclusion. They thought, that means permits are gone. No, that is not what happened. The court made clear that states can still use what are called shall-issue systems. That just means if you meet clear, objective rules, like a background check, fingerprinting, or training, the state generally has to issue the permit. They cannot play favorites. They cannot say yes to celebrities and no to regular people. They cannot tell you that your life is not important enough. That is the real shift. So when people say the Supreme Court ended gun permits, what they usually mean is this. The court ended one kind of permit abuse. It ended the kind of permit system where government officials had broad power to say, convince me. And if they were not impressed, your rights were gone. Let me break this down even more. First thing, the court did not ban every permit in America. Second, it did block states from demanding a special need before issuing a public carry permit. Third, it changed the legal standard for gun cases across the country. And fourth, it forced anti-gun states to rewrite their playbook almost overnight. That is why this case still matters so much. Now, most people think the biggest danger is getting denied a permit. But the truth is even worse. The real danger is thinking the law changed more than it did, then making a move based on bad information. If you live in a constitutional carry state, you may not think much about permits. But if you travel, move, or carry across state lines, you absolutely should. Imagine you live in one state where permitless carry is allowed. Then you drive into another state that still requires a permit, still has sensitive place rules, and still has strict rules about where you can carry. If you think Bruen ended permits everywhere, you could break the law before lunch. That is why this matters for every state, not just New York. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police ask about your gun. Subscribe so you don't miss it, because one bad sentence during a stop can create a mess you never needed. Now, let me explain what happened after the Supreme Court dropped that ruling, because this is where it gets interesting. States like New York did not just give up. They moved fast, very fast. They rewrote their laws. They changed permit standards. They expanded lists of so-called sensitive places. They added more training rules, more paperwork, more restrictions, and more places where carrying was banned. In other words, they lost one tool and reached for five others. That is the part nobody talks about enough. A lot of gun owners celebrated the decision and thought the fight was over. It was not over. It was just moving to a new battlefield. The question changed from, can states demand special cause, to, how far can states go in controlling carry without violating the Second Amendment? And that fight is still happening. In 2025, the Supreme Court refused to hear a challenge to parts of New York's new post-Bruen law. That does not mean the court blessed every restriction forever. But it does show something important. Permit systems still exist. Sensitive place restrictions still exist. Licensing rules still exist. So if you are waiting for some magic moment when every permit requirement disappears, do not hold your breath. Here's what most people get wrong. They confuse a win on principle with a win on every detail. Bruen was a huge win on principle. It said the right to bear arms includes public carry for ordinary self-defense. That matters. But it did not erase every fight about where you can carry, what process a state can use, or what conditions they can attach. That means your state still matters. Your local rules still matter. Your travel plans still matter. Let's make this real. Imagine you finally get your permit in a shall-issue state. You did the class, you passed the background check, you paid the fee. You carry every day and you think you are covered. Then you take a weekend trip into a state with strict location rules. You stop for dinner. You step into a posted private business. You walk past a government building. You cross into a transit area. Suddenly, the issue is not whether you had a right to get the permit. The issue is whether you carried in a place that state says is off limits. Do you see the trap? The permit question is only one part of the problem. The carrying question is the bigger one. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And let me say something else that may surprise you. In some states, permits are still very important even if permitless carry exists. Why? Because permits can affect reciprocity, which means whether another state honors your right to carry there. They can affect purchases in some places. They can affect how law enforcement sees your status during a stop. So do not make the mistake of thinking, if my state allows permitless carry, permits are useless now. That is not always true. Here's a hypothetical example to explain this. Let's say Tom lives in a permitless carry state. He decides not to get a permit because he thinks he does not need one. Then he drives 2 states over for a family trip. That other state does not honor permitless carry from his home state, but it does honor actual permits from certain states. Tom gets pulled over while carrying. He tells the officer he thought the Supreme Court ended permit rules. That argument is not going to rescue him. That is how people get burned. And here is the bigger warning. The court's decision gave people more legal protection against unfair permit systems. It did not give people a free pass to stop learning their own state law. If anything, the ruling made legal literacy more important, because now you have states trying to push right up to the line of what they think the court will allow. That means more lawsuits, more confusion, more headlines, more bad information. Hey, 73% of people watching videos like this usually are not subscribed. Do not be part of that group. Join the gun owners who stay ahead of these updates instead of hearing about them after a law changes, after a case is decided, or after a bad arrest goes viral. Click subscribe and stay informed. Now let me break down what this means for every state, because this is the part that affects you directly. If you live in a shall-issue state, the biggest takeaway is this. Your permit system is probably still alive, but the state has less room to deny you for vague reasons. That is good news. It means the government usually has to use clear rules instead of personal opinions. If you live in a former may-issue state, your world changed the most. States like New York and California had to rethink how they handled carry permits. They could not keep telling regular citizens, "You have not shown enough need." That wall came down. If you live in a constitutional carry state, do not tune out. Your state may let you carry without a permit, but other states do not have to follow your rules. And if you travel, hunting trip rules, hotel stays, road trips, airport zones, posted property, and city-specific restrictions can still matter a lot. If you live in a state with aggressive gun control laws, watch what your lawmakers do next. Some lawmakers stopped using open discretion and started using layers of conditions instead. Training hours, interview rules, character standards, restricted locations, business property rules, storage rules, transportation rules. The strategy changed, but the pressure stayed. And if you are asking, so who really won? The answer is complicated. Gun rights supporters won a major constitutional point. The right to carry for self-defense got stronger. States still kept room to regulate permits using objective rules, and anti-gun states started searching for new ways to keep control. That is why this issue is not going away. But wait, there is something even more important. The court also changed how judges are supposed to review gun laws. Instead of using flexible balancing tests that often favored the government, the court said judges should ask whether a gun restriction fits with the nation's historical tradition of firearm regulation. That sounds technical, but the real-world effect is huge. It means states now have to defend gun laws by pointing to history, not just policy arguments. And that has launched challenge after challenge across the country. Some laws survived, some did not. Some are still tied up in court. That is why the legal map keeps moving. So what should you do with all this? Number 1, stop repeating the phrase, "The Supreme Court ended gun permits," like it is the whole truth. It is not. Number 2, learn your own state's carry rules and the rules of every state you travel to. Number 3, understand the difference between getting a permit and carrying legally after you get one. Number 4, do not rely on social media clips for legal advice. And number 5, pay attention to what your state did after Bruen, because that is where the real practical impact often shows up. This information could literally change again as new cases move through the courts. Subscribe now, because the next video explains exactly how to protect yourself from the most common permit mistake people make after a major court ruling, and waiting until after a stop, charge, or denial is way too late. So here's the bottom line. The Supreme Court did not erase every gun permit in America. What it really did was end the old game where certain states could force ordinary people to prove they were special before exercising a basic right. That changed everything, but it did not end the legal fight. Your rights are strongest when your knowledge is strong too. So subscribe, stay sharp, and keep learning, because the worst time to learn your state's carry rules is after you have already broken one. And remember, this video is for educational purposes only. It is not legal advice, and the law can be different depending on your state, your facts, and the next court decision.